let's continue, shall we? Yes, I think we will. The all-important Commerce Clause and the individual mandate. The individual mandate is about you. Mandating you. And by the way, as a significant side point, Roberts, in his ruling, and the four originalists on the court, and I would include Kennedy in this particular case, they both agreed on something I've been trying to explain over and over again to address Obama's big lie. These 30 million people without health insurance, the vast majority of them are young people. They're young adults. And Roberts and the four dissenters both pointed out those young adults, those 30 million or so, my words, they are dragged into this system. They're one of the major funding mechanisms for Obamacare. And when he goes out and says, I'm covering 30 million people, he's stealing from 30 million people. Please remember that. This is a targeted class that are being put upon to take their money from them, to separate them from their money, not to give them coverage. So remember that. Young people in particular. You're the target. You're not the beneficiary. So Roberts and the four dissenting justices agree that Obamacare goes well beyond the Commerce Clause of the Constitution. That should have been the end of it right there. Case closed, over and out, goodbye. Congress, you can rewrite a law with the president, not rewrite a law. In other words, Congress can still bumble along. The president can still try his little fiats and all the rest and keep having people sue him and try and stop it. That's fine. But that should have been it, over and out. But it wasn't. No, he said, I've got to save this law. How can I save it? What would Harry Blackmun do? Where can I go? What can I... Oh, the tax clause. So Roberts asserts the court has a duty to apply statutory construction rules that require the court to uphold the constitutionality of statute if there's a reasonable reading of the statute that would justify upholding it, even if Congress didn't mean to or knew what it was doing. Those knuckleheads in Congress... Oh, they kept trying to figure out what to call it. We'll call it a penalty, call it a fine. Gee, we don't know what else to call it. That light bulb never went off for the word tax, the all-important word. So Roberts supplied it for them. He said every reasonable construction must be resorted to in order to save a statute from unconstitutionality. He even says that his reading is not the, quote, most natural interpretation, unquote, or even, quote, the most straightforward, unquote, interpretation of the statute. So I would ask George Will and Krauthammer and these other guys, is this how a justice is supposed to work? Is this how a justice is supposed to go through this process? Fumbling around, mumbling around, lurching here, lurching there? Making incoherent statements and writing? And yet Roberts essentially says that while Congress did not mean or know that the individual mandate is a tax, in fact, you and I know they said it wasn't, the court must treat it as a tax if that's the only way the law can be found to be constitutional, even when the court just finished saying it was not a tax for the purposes of the Anti-Injunction Act. That is, for standing or ripeness purposes. He even said, it is of course true that the Act describes the payment as a penalty, not a tax. But while the label is fatal to the application in the case of the Anti-Injunction Act, it does not determine whether the payment may be viewed as an exercise of Congress's taxing power. Why is that? I don't know, because he said so. The tax analysis is utterly incoherent. He says the mandate's a tax, but he doesn't say what kind of tax. Now, that's kind of crucial for reasons I explained before. Says it's not a direct tax, but he says it looks like a tax in many ways, functions like a tax, therefore it must be a tax. Circular, incoherent explanation we'd expect from, say, Justice Breyer. So instead of focusing on the Constitution's requirements for taxation, he applies a functional test. Where does he get the functional test from? No, I don't know. He says the dissent, the four originalists, they're hung up on labels. Well, yeah, they kind of are. Yeah, because those labels are words, and they happen to be in the Constitution. Hung up on labels, you know. Tax, penalty. You know, those labels that make the difference between something that is and is not lawful. And you know what he did? Did something liberals do all the time, even the most moronic callers to my program who are liberals. He referred to the General Welfare Clause. The General Welfare Clause, even James Madison explained that didn't substitute for enumerated powers. Last time I checked, Madison is said to be the father of the Constitution, whether he was or not. Under Article 1, Section 8, Clause 1, General Welfare Clause. That's where we find this stuff. The General Welfare Clause, of course, has nothing to do with this. But there it is. Now, on Medicaid, the law requires states to dramatically increase their Medicaid programs or have all federal Medicaid funds withheld, including funds for existing Medicaid programs that states are implementing. And the court ruled 7-2, Ginsburg and Sotomayor holding out. By the way, this Ginsburg, you read her opinion, she's about as radical a leftist as you can imagine on the court. She has nothing but contempt for the Constitution. Not only in her interviews about, she prefers the South African Constitution or whatever, but just read her writing in this case. She's a disgrace. But then again, so the court held 7-2 that the federal government cannot hold a gun to a state's head to compel participation in a federal program. So they can't withhold, I think I understand, that they can't withhold the feds money from existing Medicaid programs to compel the state to participate in the Obamacare program. What a great victory, huh? Every time they allow just a little piece of the Constitution to survive, we're supposed to clap like seals. This is a slam dunk case, ladies and gentlemen. This Obamacare should have been killed. But look at this. Look at what we have to go through, the contortions. We're twisting ourselves into pretzels. Well, at least he did. I'm going to get to this George Will piece in a second. Now the dissent. They said judicial tax writing is particularly troubling. Taxes have never been popular, and in part for that reason, the Constitution requires tax increases to originate in the House of Representatives. We have no doubt that Congress knew precisely what it was doing when it rejected an earlier version of this legislation that imposed a tax instead of a requirement with a penalty. You got that? So Congress's collective eyes were wide open. And the reason they didn't want to impose a tax, ladies and gentlemen, is because the president made a pledge not to tax the middle class. Everybody knows this. I think even the 9 citizens on the Supreme Court, certainly 4 of them did. They put it in their opinion. Imposing a tax through judicial legislation, wrote the minority, inverts the constitutional scheme and places the power to tax in the branch of government least accountable to the citizenry. They said the question's not whether Congress had the power to frame the mandate as a tax, but whether it did so. It may be reasonable to find that Congress did, but we cannot rewrite the statute to be what it's not. And yet that's exactly what John Roberts did. And of course the 4 leftists on the court, they're more than happy to rewrite anything. And they also said the four justices in the dissent, we must observe that rewriting 5000A, that is the penalty section, as a tax in order to sustain its constitutionality would force us to confront a difficult constitutional question. That is, whether this is a direct tax that must be apportioned among the states according to their population. Article 1, Section 9, Clause 4. Oh, you're just labeling stuff. They point out the government's opening brief did not even address the question, perhaps because until today, no federal court has accepted the implausible argument that the penalty section is an exercise of the tax power. Not a single district court, none of the circuit courts. But John Roberts, smarter than everybody, he figured it out. He read the minds of Nancy Pelosi, such as it is, Harry Reid, such as it is. Yeah, they really meant a tax, not a penalty. And once the respondents raised the issue, the government devoted a mere 21 lines of its reply brief to the issue. At oral argument, the most prolonged statement about the issue was slightly over 50 words. One would expect this court to demand more than fly-by-night briefing and argument before deciding a difficult constitutional question of first impression, said the dissenters. You know what really sticks in my craw, ladies and gentlemen? We had Anthony Kennedy voting to throw out the entire statute. And John Roberts with this Mickey Mouse decision. And that's what it is. It's Mickey Mouse. Saving Obamacare as a constitutional matter. We'll deal with the politics later. We now have constitutional precedent. That's the problem. There's nothing good about this decision. Ignore the spin. Ignore the people who think they're so damn smart. They're not. Well, at least we're able to live at the confines of the Commerce Clause. We would have done that anyway if he had voted with the four dissenters. And let me tell you something else. Even that's temporary. All they need is one more liberal on the bench. They don't give a damn about precedent that they don't agree with. Oh, look at that. Whoa, that court was wrong. It's the Commerce Clause, not the Taxing Clause. What a disaster. What an absolute disaster this is as a constitutional matter. And it's a pathetic disaster. It's a poorly written decision. It's illogical. In many respects, it's incoherent. Justice Roberts relies on tax provisions, and he doesn't even tell us what kind of tax it is. And most of your kids even know. They've heard the audio of Obama. They've heard the other members of Congress. Not a tax. Strenuously arguing it's not a tax. It's not a tax. But Justice Roberts says it is a tax. So who would know better? The people who wrote this monstrous law or Justice Roberts? Who would know better whether it was a tax or not?